Hi, everyone. I'm Smita Rajmohan, the chair of the Science and Technology Law Committee of the Young Lawyers Division at the ABA. Today's event is being co-sponsored by the Science and Technology Law Committee and the Cybersecurity Task Force at the ABA. Thank you all for joining us for this fireside chat with Chetan Gupta, where he talks about the journey of a data protection lawyer. Chetan is a senior data protection counsel at Twitter in San Francisco with a decade of experience in privacy counseling. He has law degrees from Oxford and Berkeley. Chetan's paper on the market's law of privacy won the Privacy Papers for Policymakers Award from the Future of Privacy Forum, and he was later invited to present his paper before the US Senate. Joining and guiding this conversation today will be David Wheeler, who is a partner at Neil Gerber and Eisenberg in Chicago. He represents and counsels companies on data security and privacy, intellectual property, information technology, and e-commerce. His background as a software developer and information technology experience serves him well in this position. Before we proceed to the discussion, I'd like to hand off to Charlene Goldfield, who is the Young Lawyers Division Liaison for the Cybersecurity Task Force for the ABA, to say a few words about the vital work they do in the field of cybersecurity. Charlene?
Yes, thank you so much, Smita, and thank you to the YLD, or Young Lawyers Division Science and Technology Committee, for having me and for having this discussion as well. Just to briefly summarize about the task force, I currently serve as a liaison for the Young Lawyers Division, and we have many other liaisons and that represent all sections and divisions of the ABA. So we comprise a big group of individuals that are here to serve as a resource for all things cybersecurity. Our goal is to provide resources and advice on matters affecting how lawyers protect their practices and their clients' confidential information and intellectual property during a cyber attack. So in other words, we're here as a subject matter expert, and you can definitely rely on us if you ever need anything, any advice or resources. We just recently launched a free vendor contracting checklist, which focuses on providing a resource to solo and small firm attorneys who interact with vendors, often involving access to client-sensitive data or internal systems. So to check out our resources or to find out more information about our materials, please, you can go ahead and search for us on the American Bar Association website under Cybersecurity Legal Task Force. Just go ahead and search for us up on the search tab, or you can go directly to our website at americanbar.org/groups/cybersecurity. So in other words, thank you so much again. And now I want to hand it over to one of my task force colleagues, Mr. David Wheeler, to start the discussion.
Hi all, how's everybody doing today? Chetan, I'm looking for your screen.
All good here.
All good, all right. Perfect, so let's get the conversation started. Obviously you and I have different paths that we took to become privacy and cybersecurity lawyers. Why don't you tell us about yours and the path that you took?
Sure, happy to do that. And I think it's a really interesting topic because privacy is a field where I don't think 2 decades back this is a well-defined path to become a privacy lawyer. It's everybody has interesting paths as a profession today. For me, so my first brush with privacy was actually through constitutional law, because that was my first love in law. And my first master's degree was centered around human rights, so almost like a Fourth Amendment take on privacy. And then when I moved to the US, I came to Berkeley to do a master's, and I had a professor, Chris Hufnagel, who had a bit of a technical background, and he had this interesting idea to host a joint course between the School of Information and the School of Law, which at least in 2016 was relatively novel. And it was a really good idea though, because I think still in the field there are not enough engineers and lawyers talking to each other, and they're trying to do the same thing but coming at it from different directions. But this course was great because the GDPR was coming up on the horizon, and Chris made it clear like this is going to be a sea change to how society generally views privacy. And there was also the opportunity to sort of engage on technological issues with sort of counterparts in a different field. So for example, one of the projects that I worked on as part of the course was we bought a Samsung Smart Cam, and as a lawyer, I looked at the sort of privacy policy and said, okay, what privacy promises are being made here? And then I worked with a counterpart in School of Information to actually use MITM proxy and other software to analyze the packets that were being sent out to the cloud to see how those sort of privacy promises married up on the technological side. And I think those are sort of increasingly the kind of conversations you will need to have as a privacy professional in the field.
Yeah, it's very fascinating. And I think you hit the nail right on the head there when you talk about new technology being offered to the consuming public. And we, as consumers, we all see these great new applications, these great new devices, these great new connections to the internet, but we rarely think about what does that really mean in terms of how these things work and what information these devices are gathering. And I think that curiosity is kind of a natural tool skill or tool set that I think young lawyers should feel toward reviewing new technology, for reviewing its application in the e-commerce ecosystem, so to speak.
Yeah, I couldn't agree more. Like, you can just still learn so much just by tinkering with stuff and seeing how it works. So after Berkeley, I started working at Baker McKenzie, which is a large multinational law firm. Actually started out doing employee privacy, and sort of then branched out into more general privacy counseling. Helped a bunch of companies deal with GDPR readiness. I think about 50 clients at one point. Getting ready for GDPR, and then similar wave of prep for the CCPA. It was really fascinating. Baker has offices in almost every country in the world. So doing these large scale surveys on things like, oh, we want to have self-driving cars drive around and collect data to train algorithms. How does that play out in 70 different jurisdictions was really fascinating.
It is. And my path to technology and privacy was a little bit different because, you know, I did a lot of work for the Department of Defense with regard to C and C++ programming. And then before I even went to law school, I went to business school and became an investment banker. And having worked in environments where you have to have confidentiality as kind of a prime directive, it was very important to kind of see that operationally, how privacy and cybersecurity relate to customer products and customer interactions. And so going to law school was kind of the next step for me. But I actually came down the path of litigation in the class action world, which led to a lot of privacy issues early on with the consumer financial services market and you know, bank loans and predatory lending. So slightly different path, but I think it gave me a lot of tool sets with regard to the nuance, with regard to kind of class issues that might, you know, perk up around privacy considerations and cybersecurity considerations.
And I'd be curious to actually also hear about your background as a software developer and where does that fit into your story? Like, it's sort of
I think that having had that experience, you know, provided me a great pathway to this field. And again, I was working for a defense contractor, and we were actually developing C and C++ programs to do modeling, to do predictive modeling with regard to war fights. For that matter. So we would take some major end item like a tank, and we would see how it might operate with its, you know, resupply and repair cycles in a war field based on some factors. So it was kind of the fascinating, it may be beginnings of AI a little bit, you know, but very fascinating developing new technologies like C and C++. I think C++ had just started to gain foothold in the programming world, and prior to that, I was doing, you know, Fortran and Pascal and Visual Basic and things like that. But having been immersed in that, you know, technological, vernacular and seeing how things operate, I think really helped me gain insight into, you know, developing of databases, using databases to collect, you know, broad demographic data, and how that data can be analyzed, whether it's through regressions and so forth, and how it can be used to do predictive modeling, which of course is the heart of the privacy concern, because obviously the issue is, you know, how much data should a company have, and how much should that data be able to tell them about us as individuals on a daily basis. So that part of it really linked up to the law.
Yeah, that's really cool. And I find that Twitter also particularly, Twitter allows you to do like one personal goal every year. So my goal this year is actually to learn Python so I can actually work with our data science teams a little better, because like you said, it just helps if you speak their language and know how these systems work.
I think that's right. There's not a day that goes by that I don't see a new language that I wonder if I could learn this language. And I kind of read it, and it's all modeled after the same base language with C and C++. So some of the things look very familiar right away, but then, you know, there's always the nuances for each language. But yeah, I've done a little bit of dabbling myself just to try to make sure I stay abreast of kind of the tech talk and, you know, the coding structures and things.
Cool. Yeah, I mean, I guess to wrap up the sort of career section of the talk for me, after a few years at Baker, what I found is by structure, and Dave, I'd be curious to hear your thoughts on this too. But by structure, the level of your involvement with each client. I mean, you can get deeply involved in a long project, but more often the scope of your involvement tends to be you come in for a project, you do your bit, and you don't always have visibility into how the business side of things play out, or what necessarily happens after you sort of given your advice and moved on. So I was keener to dive deeper into one world, I guess. So that's what prompted me to start looking for in-house roles, and I think the social media companies in general are just play such an interesting role in our society now. So Twitter was a great, looked like a great choice. And I have to say, I haven't had a dull day on the job so far.
Yeah, and you know, the other aspect of that is, well, social media companies are important. You know, online retailers are also important, and how they're tracking your purchases, and how things like, you know, from sale to delivery, you know, the last mile, and how all those things work. And that gave me a lot of insight, and it was very helpful to work with some major retailers on the development of their e-commerce platforms. And like you said, you start to peel back the onion to figure out, you know, that, you know, the first is, oh, this is how we use customer data. Then you do a little bit more digging, then all of a sudden you find out, well, we're also using it like this. So it's very fascinating to dig into those compliance issues as you get more familiar with a particular client's use of the data, or proposed use of the data. So it's fascinating on my end as well from that perspective.
For sure. And did you work at multiple law firms, Dave? Have you always been at the law firm you're at now?
Yeah. I started off at a medium-sized firm, and that firm was one of the first firms. And I've been out for a while. I was going to be the Y2K guy, so just to give everybody kind of a time frame, I came out of law school in '99 and was hired by a young partner at a medium-sized firm who wanted to really start, you know, a computer law practice. And he saw my background, and it was great. And it was fascinating because we were just on kind of the edge of the .com burst, but there were also a lot of new e-commerce models coming out, like e-banking and so forth. So I had a chance to kind of cut my teeth on some pretty prime issues with regard to the development of law and technology. And then later on, shortly after that, I was recruited by another firm, a bigger firm, to do the class action work I talked about earlier. And as the consumer financial world, services was obviously based on a lot of financial issues, but every now and then a privacy issue would come up with regard to, for instance, data files that were being used to sell loans to folks, you know, where there was predatory lending issues and things of that nature. So that kind of cut my teeth, and that was back in 2002, 2001, that time frame. And since then, I've gone headfirst into it. And just about every aspect of my practice since then has dealt with either e-commerce, data privacy, and now more recently, more heavily on cybersecurity.
Very cool. And I wonder if the audience would sort of benefit from both of us giving an overview of what we see as like the buckets of privacy and security work.
Oh, absolutely. Yeah. And we'll start with the in-house role and out.
Yeah, I can kick us off. There's obviously, like I mentioned earlier, there's the GDPR in Europe, which is the big regulation for European data, and has had sort of a domino effect in terms of forcing companies globally to grapple with privacy and data protection. And you see other countries like Brazil and India coming up with similar laws, and sort of taken over the field in the sense that that's the model now. I feel like everyone looks at if any new jurisdiction wants to draft a privacy law, it's all, they always go look at GDPR and do something off of it. It's captured the imagination. And in the US, obviously, we don't have a federal privacy law yet, but you have in California, you have a bunch of different legislation, including the California CCPA. And then we're seeing a patchwork of different state laws. Dave, do you want to talk a little bit about the sectoral laws that you see in your practice too?
Sure, and I'll mention, you mentioned GDPR and how the U.S. doesn't really have a central framework, but surprisingly in the U.S. we do have, I think, the building blocks for a really strong essential framework. And if you look at the National Institute of Standards and the publications that they've come out with, which were originally drafted for government contracting and government work, but now have been rewritten in a lot of cases to encompass businesses in general. And some of those standards have now worked their way into laws. And like you mentioned, sectoral laws, we'll talk about some state laws as well. Like Ohio, for instance, builds into its law a safe harbor for anybody who can demonstrate that they have a NIST or similar compliant, cybersecurity program, and that provides you a safe harbor or an affirmative defense for cyber breaches and things of that nature. The same thing with New York, and I think we're going to see more and more states kind of adopt that approach. And you talk about the CCPA and the Virginia privacy law, which kind of took a different approach. People argue that it's more pro-business, but it still accomplishes, I think, the same things, which is respecting the privacy of the individual and giving those individuals a platform to contest. And then, of course, there's other things like the self-regulatory frameworks like PCI DSS, and then we have the more industry-related issues like HIPAA, for instance, HIPAA High Tech, which imposes a high level of security and privacy standards with regard to medical data. And on a daily basis, I see all of those things across the spectrum, whether it's, helping a client respond to a data breach and how we might want to affect that, whether it's, helping a company understand whether or not they have a HIPAA obligation with regard to third-party contractors who are handling internal company data and so forth. So we see it a lot. There are a lot of different regimes, industries, frameworks that apply to data privacy and cybersecurity on a daily basis. So it's why it's helpful to look at, I think, the state laws and things like GDPR and the Canadian law. It's also very helpful to kind of look at the standards and how they're evolving over time and what might be out over the horizon with regard to the next line of frameworks that can be applied nationally to cybersecurity and privacy issues.
For sure. And another really interesting trend, which I'd also talked about in the paper I wrote, but is the fact that industry players often end up setting standards that actually have more impact than legislation sometimes. And I find that just fascinating. And to take two recent examples, I guess, Apple launched the Ask to Track framework for new apps. And I can honestly say at Twitter, we've probably spent more time dealing with that than any other single piece of legislation, preparing to comply with the private company's framework. And I just find that fascinating that the standards are sort of in some, and it definitely delivers us tangible improvements to consumer privacy and security.
And I think that's good. I think that's good because that's where the brain power is. Those private organizations, they have their finger on the pulse of the issues that might come about. And if you start to overlay that with the requirements of a GDPR, the requirements of a privacy by design framework, the requirements of a cybersecurity, all of a sudden you start to get real innovation with regard to protecting data and going forward. Now, whether or not that'll be translated into some national legal framework at some point is another thing, because the law is always playing catch up. But I think you're right. The innovation's there and the ability and understanding the issue of how important it is to individuals with regard to privacy rights. And the innovators can really take charge and have that kind of market proliferation that you're talking about.
And I think that's like a common theme for our conversation, that the technology and law need to intersect and do a better job of intersecting. And I think that's the point you're making too, that folks at some of these companies are in some ways better exposed to technology in order to drive regulation, which is why it comes out of there sometimes. But I think it's a fascinating trend. I'm happy to sort of talk about the different kinds of privacy work I see, privacy and security work I see in-house, Dave, and then maybe you can provide a perspective on what that looks like from the outside, because we also rely heavily on folks like you to keep us honest and keep the wheels on the bus sometimes.
Sure.
Yeah, and what's interesting for me is I think the general expectation would be that a privacy security lawyer does all of the things we're going to talk about, but increasingly, at least I see these things, each of these things we're going to talk about become more and more specialized and almost its own own domain, which I wouldn't have imagined would happen, but seems to be happening. And I guess the first bucket of work I can talk about is sort of privacy counseling and sort of data protection impact assessments. And to unpack that a little bit, at least for European data, the GDPR requires that if you're engaging in data processing, which presents a high risk to rights and freedoms, you must subject it to slightly more intense scrutiny and review internally through a process called the data protection impact assessment. So if you're a privacy lawyer in-house, most companies now have some version of a development life cycle, which hopefully brings in privacy sooner rather than later. So you get to review new products and services or changes to old products and services and sort of look at them and say, what data are we collecting here? How long are we going to keep it? Who has access to it? Are we doing anything which would be surprising to consumers? Should we be communicating it more proactively or differently? And I wonder, Dave, like, do you have clients coming to you for some of the more sensitive or touchy DPIs for help with navigating those?
Oh, absolutely. And again, when we talk about sensitive data and going to your point about the assessments, we start with a very simple, hey, let's just do a data map. And we have a data mapping tool that allows us to kind of, get an inventory of the processes, the data elements and things that people are acting on, the ones that, we ask, what vendors have access to this data? How do you envision being used in the future? What are your retention expectations with regard to this data? So the data map is essential. And we see a lot of clients, we help a lot of clients out with that initial data map. And once we get that data map, then we move on to the assessment, where does the risk lie? And so it's very, very helpful. See it on a daily basis. Absolutely. Yeah.
Yeah, and big plus one on the data. Like you said, that's really the building block, and the companies that did the work early with GDPR and CCP are in good shape for CCP and other regimes. And if you're playing catch up, it becomes harder because there's more data coming through the door every day.
That's right. And now that you have a way to kind of categorize it and classify it and record it, it just makes it easier because now you can have a consistent framework to go to and look at and make that assessment. Makes that assessment a little bit easier.
And as a sort of general practice point, I don't know if you see this with a lot of your clients, Dave, but often in-house we look at a new legal requirement and we often ask ourselves, does it make sense to make this a jurisdiction specific thing? Or if we're going to do it, we may as well do it for everyone. Like if we're going to create access rights to data or deletion rights to data, does it really make sense to cabin it by jurisdiction, or should we just make it a platform-wide thing?
Yeah, that's the beauty of abstraction, taking those requirements and saying, hey, these things have applicability beyond just this jurisdiction is asking us to do it. And do they make sense beyond just this jurisdiction? In a lot of cases, they do. And it's as simple as that. And that's again, going back to that point where the people who have their fingers on this type of stuff on a daily basis can see it. And then, again, it folds into your privacy by design and it just makes your job a lot easier. Yeah.
I guess the next bucket of stuff I see is GDPR and other laws require that if you're transferring data between two entities, you have some sort of contract which defines what protections that data receives. GDPR has roles of controller and processor and requirements for what those contracts must look like. So we obviously have to look at various data flows, both inbound and outbound, and make sure we have the right contracts or data processing agreements in place for each of those data transfers. And of course, with the new standard contractual clauses that just came out, it makes the framework they use now is a little bit better because now we can break it out into those 4 different types of relationships, whether it's processor to processor or processor to controller, controller to controller, and so forth. And the beauty about the new standard contractual clauses is, hey, they are what they are, and not too much goes into negotiation, but just making sure that you have the right model
applied to your data transfer is important in understanding, what the terms and how the differences might act, for instance, between a controller and a processor, or a controller to controller, or processor to controller, and so forth. So data processing agreements are very important, and always on the cybersecurity side, in today's environment where we have issues with regard to supply chain, it's always important to make sure that those data processing agreements also contain a flavoring for cybersecurity, and with a clear instruction on how the data is to be used and who can access the data. And if there is a deviation from that, the notice requirement that comes out of that.
Yep.
Very important.
And you teed up the next point perfectly, which is the next sort of bucket I was going to talk about is breaches and incident response.
And
again, many laws now, including the GDPR, require regulatory notification if you suffered a data breach, which means improper access or exposure of personal data. So at Twitter, for example, we have a fairly well-defined incident response process that's led by our InfoSec team, and they know to pull us in early and quickly, so we can meet the regulatory reporting windows, which can be fairly short. In the GDPR's case, it's 72 hours. But I'm one of the people who's on the incident response team. I actually find it a really interesting area of work. It can be mildly stressful at times because you're under the gun in terms of the clock. But I also find it exposes you to a lot of different systems inside the company, and you engage with a lot of different teams.
Absolutely. And one of the areas where we help clients out a lot is doing that tabletop exercise. Making sure that, that you've gone through several scenarios just to see how you respond and to see what, what areas might be lacking, what areas might need improvement. But more than anything else, that affords you a level of relaxation when something does happen. You kind of know the steps to take. You're not panicking. You're not running around trying to figure out. You have a set of steps. You've tested them. You know who to reach out and contact and so forth. So that's a very important aspect of our practice, as well as helping clients kind of work through or testing their incident response.
For sure, and imagine the next thing I was going to talk about is interacting with regulators, which, as I mentioned, you have mandatory reporting requirements for breaches. And what we found at Twitter is we sort of use a very conservative definition of data breaches. So which technically meets the GDPR definition, like if an email goes to the wrong recipient, you share a Google Drive folder with the wrong set of people, we report those things as data breaches. And we've found that it's actually helpful in terms of getting regulators to understand our systems with respect to these issues, and actually have a more sort of normal, regular relationship with regulators if you talk to them more often, rather than just giving them the one big data breach of the year or whatever when that happens.
That's very true. Early on in the process, where we had to report data breaches to states attorneys general, sometimes you'd get a great response like, "Thank you, because no one ever does this for us." And other times you might get a response as, "Why are you sending this to me?" So, right. but you have to do it. And as a litigator, that's where we kind of come in and help counsel clients with regard to, hey, let us get out in front of this. Let us be the one interacting with the regulators in this regard, because we can manage the communications, manage the responses, just to make sure that we're not overly exposing the risk associated with certain data breaches.
For sure. I mean, that's definitely an area we rely heavily on outside counsel for, also to figure out state notification requirements and what's needed in each state for some breaches. And like you mentioned, just talking with, say, the FTC, and I've actually seen two different types of sort of FTC inquiries in my time at Twitter. One is where the questions are directed at you as the entity. It's an investigation into your practices, but then there's also 6B sort of wide-ranging information requests, which are also kind of interesting. You get the sense that the FTC and these other regulatory agencies are trying to build a picture of the market to see what all the players in this sector are doing. And again, we rely heavily on outside counsel like Dave to help us structure our responses to those things, to figure out what's the right amount of information to be providing in those contexts.
That's exactly right. That's where we provide a lot of value to clients who are facing those situations. And I'm not sure how much the landscape is going to change as the amount of ransomware attacks ramp up, but there's also issues with regard to paying ransom and whether or not you can get in trouble with other regulatory agencies for, lo and behold, heaven forbid, supporting terrorists, if you pay a ransom. So there's a lot of pitfalls that you have to watch out for. So,
And the last bucket of work I was going to mention was we obviously, as a social media company, Twitter gets a lot of requests from account holders to access data, or they're locked into their accounts, or they're unhappy with something on the platform. So my team is responsible for dealing with those requests, and some of them end up getting escalated to regulators. Others are escalated through other channels, but sort of coming up and define with the framework for dealing with those requests and responding to them in a timely fashion is another steady stream of work, I'd say, that could easily be, I feel like, a career on its own now, with so many laws having so many different requirements for data access and other data.
Right. And with the CCPA in particular, the number of requests that you have to respond to and how you have to respond to those requests, it can get tricky. With regard to verification and things of that nature. And some clients prefer to rely on third parties who can handle that process for them. Others can do it in-house, but there's a broad spectrum of response postures that I think you have to be aware of and to help people through with regard to the obligations.
And like I said before, I feel like we at least rely heavily on outside counsel also to help keep track of all these new because it feels like a new privacy law or requirement springs up almost every week now.
All the time. And I think, again, I think the environment's changing, the ecosystem's changing. I think that, people are going to start pushing for more cybersecurity laws. We've seen it in all various industries like the insurance industry, the healthcare industry. And I think it's only a matter of time before we start to really see some national frameworks come about. I think it only makes sense as we become more globalized. Foreign companies don't want to deal with 50 states, different laws. It would be so much easier for global commerce to engage with somebody who has a national framework versus looking at multiple frameworks within the nation to handle privacy and cybersecurity issues. So we're always taking a look at that, what the legislative posture looks like, where the laws seem to be going in terms of bills being introduced. So we stay on top of that as well.
I wonder if, in closing, do you have takeaways for sort of young practitioners getting into the field? If you were to do something differently as you look back on your career, would you have done something differently, or do you have other takeaways?
Wow, that's a good question. I think for me, if I had planned the way my career path went, and with the skill sets that I got from different ages, you'd call me a genius. I didn't plan it, but it worked out that way. And so for an aspiring lawyer, I would say definitely pay attention to developing a working knowledge of technology, of coding, of database, relationship database management, database, data in general. I would say also gather a healthy understanding of how legislation works, how laws are developed and how they're passed. And then finally, just being very astute about the changes in the law with regard to standard of care in the cyberspace, in the privacy space, and so forth. I think as long as you have those natural curiosities in those areas, I think you're going to be fine as a young lawyer coming into this area.
Yeah, big plus one for that. I think my big takeaway would just be technologically curious. I think the field, I don't think you can be a pure privacy lawyer in the future. You're invariably going to have a sound understanding of technology and how it affects the sector you're in. That's right. Yeah, that would be my big takeaway. But thanks for taking the time to chat, Dave. I really enjoyed it.
Yeah, John, thank you for providing your insights. It's been very helpful for me as well. I mean, it's always good to talk to in-house on a non-emergency basis and figure out what's going on. So very helpful, and I thank you for your time.
Thank you, Dave.